to welcome to the 2022 virtual mock trial clinic. We're really excited to be able to bring this virtually again this year. Last year was our first year doing it virtually, and so we're gonna try to do it virtually every year because I understand there's people from all over the state who are here. So at this time, if you want to go ahead and give a shout out in the chat to where you're attending from, we'd love to see that, see where everybody's from. See, I got an RGB. Just hit everything on my screen. Let's see. Rio Grande Valley, Austin, El Paso, Montgomery, San Antonio, Corpus. Got some Dallas people here. Houston, Round Rock, Corpus Christi, Coppell, whatever. But Duquesne, is that how you say that one? You can definitely correct my pronunciation. Lots of El Pasos, Lubbocks. Awesome. Well, I am so excited to have all of you here. I'm going to try to share my PowerPoint at this time. Hopefully it works. Okay, if someone can just type in the chat that you can see the PowerPoint for me. Yes, perfect. Thanks, Jamie. Okay, and at this time, I guess I should have, before I shared, introduced my co-host for today. Today with me helping run this clinic is Jamie Olin and Stacy McNulty. Stacy's not feeling great today, so she may keep her camera off for a little bit, but we'll see her later on. And so at this time, I think pretty much everybody we have 87 participants in here, so I think we've got most of the people who signed up. So we're going to go ahead and move forward. If you have questions at any time, you can feel free to put them in the chat. You can message them directly to me if you don't feel comfortable putting them in the chat. You can shout out the questions when we ask for, when we say, hey, is there any questions? You can feel free to ask them out loud. We'd love to hear from you directly. You can also message Jamie as well. As I know, last year we had a lot of people who didn't necessarily feel like putting their question for the whole world to see. So you're welcome to do so anonymously through me or Jamie today. So with that, I'm going to go start the first part. Oh, there's my welcome slide. We're going to start the hello, there we go. We're going to start the first part of the presentation, which is just to do a basic rules refresher, talk about the format of the competition, generally speaking, or the format of a trial, and go through some of those basics for a lot of the newer participants this year, but it's also going to act as a refresher for those who've participated in the past, because last year we did still have a lot of virtual trials. I think this year, fingers crossed, we're planning to do every competition in person. And so that may be new for a lot of people who are even returning this year. So if you feel like I'm going too quickly, you can definitely stop and ask questions. You know, put the questions in the chat. I have it open where I can see it. And I also trust Jamie to interrupt me and let me know if there's a question that I'm not answering or don't see. So the first thing I wanted to highlight is timekeepers and how important timekeepers are. There are specific rules for timekeepers. There are specific rules for the time cards that can be used. And that's just to standardize all of it to make it very easy to follow. Really, my main thing is read the rules if you're a timekeeper. And if you're not a timekeeper, you should also read the rules to make sure you can help your timekeeper know what to do. We last year before the state competition put together a timekeeper specific version of the rules, and I'm going to make sure Melissa sends that out again this year to really help, because it seemed to help. But will we get to keep the PowerPoint after? I'm not sure. I can send it to Melissa and have her distribute the PowerPoint. Yes, there's not a lot in the PowerPoint, but we are recording this session and it will be posted, and we're going to be recording the breakout sessions as well, and those will be available to watch again after. So timekeepers are super, super, super important. Don't underestimate the importance of a timekeeper. I've seen multiple rounds. I've judged lots and lots of rounds. I know Jamie's judged lots and lots and lots of rounds where the timekeeper really can make or break a round for a team if they're not doing their job correctly. So it is really important, and I just wanted to stress that it's a super important part of your team. Okay. You should have already received the problem. The problem consists of 3 witnesses per side. All 3 witnesses must be called. You can't just call 2 of them. And you may not call any of your witnesses a hostile witness, meaning if you are on prosecution, you can't call a prosecution witness and treat them as if they're really a defense witness. And most importantly, that would be 3 different people acting as the 3 witnesses, and you can only call, like, the prosecution can only call the prosecution witnesses, the defense can only call the defense witnesses. And witnesses are bound by the statements. That's pretty much what the rule says. Read the rule, make sure you understand the rule. If there's any questions, you can send those through your coaches up to Melissa. But the main thing is you can't make up new facts for your witness statements at any point in the competition, okay? And the rule has some more specifics to it than just what I've posted on the PowerPoint as well. Okay, so our main team composition, we're gonna have 7 team members because this is not including a timekeeper. And so once you add a timekeeper, that's 7. You have 3 attorneys, 3 witnesses, and a timekeeper. You can have additional, I believe in the past couple of years, we've allowed additional roster slots, but this year, because everything's going to be back in person, we're going to be back to 10-man rosters. So that would give you room to have up to 3 alternates for any of those roles. And then also you can mix and match. You can have a different set of people on the prosecution side versus the defense side. Any 6 of the 10 members can participate. And one of those 10 is the official timekeeper. You will get rosters to fill out. Make sure you're filling out your rosters correctly. We've run into this a lot in the past couple of years where the rosters there's changes made specifically to the witnesses, and it's not clear who's portraying what witness. For the most part, those don't necessarily, that's not going to affect your scoring. What it will affect is when we're starting to pick best witnesses or best advocates. And if I don't know who actually portrayed, John Doe prosecution witness number 1, I might award outstanding witness to the wrong person. And so we want to be able to acknowledge the people who are doing an outstanding job. And when your rosters aren't correct, that becomes difficult for us to do so.
Hey, Jessica, can I interject for a second?
Yeah.
Okay, thanks. So on rosters and the team introductions of the team members, as a presiding judge, I really like to refer to the team members by their name throughout the trial. And so if the rosters aren't correct, or you just haven't had a chance to update them between rounds, if you can make sure that when you're doing team introductions, you're doing them slowly enough that the judges can write down the names of who's doing who. Sometimes I feel like teams kind of rush through the introductions because they're excited and ready to get to the actual trial. But it is actually really helpful for the judges for you to do that part a little bit slower so that we can write down the names if we need to.
Yeah, that's a great point, Jamie. And I, as a presiding judge, I also ask for introductions and I go through and make sure it matches the roster. But sometimes if we're running behind on a competition, we may not have the time to do that. We may be also trying to hurry up and catch up on time. So having the roster correct really, really helps. I see a question in the chat. Does the timekeeper count as one of the 6 members? No. So the timekeeper would be the 7th member of each round. So when we talk about the 6 members, we're talking about who is being an attorney or a witness. And then in addition, you get a timekeeper. So that would actually be 7 total. But that's a great question. For team duties, again, you're gonna have 3 attorneys and 3 witnesses. Each attorney conducts 1 direct and 1 cross, and it is completely up to you guys who does the direct and who does the cross. You don't have to assign, you know, you could even change that between rounds if you feel like someone's doing a better job crossing a different witness, for example. But I also know that that gets hard if you're trying to remember multiple witness statements. And in addition, one team member, one of the attorneys does the opening and another attorney does a closing. It is against the rules for the same attorney to open and close. And if that happens, you get 0 points for your close. So it's very important that you know that in advance, that you have 2 attorneys prepared to 1 open and 1 close, okay? And again, it doesn't really matter who opens, who closes. You get to pick among the 3 assigned attorneys for each round who opens and who closes. Opening statements must be given by both sides. If the defense waives an opening, they get 0 points for their opening. It must be given at the beginning of the trial. And I will say most presiding judges have experience doing this. I feel like if that tried to happen in my round, I would probably say, are you trying to take 0 points? I feel like Jamie would say the same thing. So you got to give your opening statements. And then finally, in terms of duties, the attorney who examines a particular witness, and by examine, we mean if you are the person doing the direct or doing the cross for witness John Doe, you are the only attorney who can make any objections regarding that witness's testimony or regarding the other side's questions of that witness. So, oops, I went on to the next slide by accident. I just want to make sure that that's clear as well. If attorney A is crossing or is examining John Doe, attorney B can't stand up during the cross-examination and make an objection. Can we then object if this happens? Normally what I see happen, like I do sometimes see it just by sheer accident or enthusiasm, right? It takes over. People are just excited. Usually the attorney realizes and they go like, oh my gosh, I'm so sorry. And they sit down and it's totally fine. It happens. But if the wrong attorney is making the objection and you're on the other side, you would just say like, Your Honor, that this isn't that attorney's witness. And just draw it to the attention of the court if we don't notice. But usually as the presiding judges, we do notice because we're sort of keeping track of who the attorneys are. It doesn't happen very often. And again, usually it's a sign of enthusiasm, not a sign of anything else. Okay, trial sequence and time limits. We start with, really what's missing here is we do normally start with a housekeeping portion, which is pretty straightforward. And then we can break that down a little bit if there's questions about what's in the housekeeping, but there's not really a time limit. That's when you do introductions. That's when you would, you know, announce whether or not you're ready. That's when you would talk to the court if there's any specific procedural issues that you have. Opening statement, you have up to 5 minutes for your opening. And again, each side must give their opening at the start of the trial. For direct and redirect, you have 25 total minutes. And for cross and recross, you have 20 minutes. And so the way that works is like when the prosecution is going, they have 25 minutes and the defense has 20 minutes for their the first 3 witnesses. And then once those first 3 witnesses are done, it flips and the defense has 25 minutes to do their directs and redirects. And the prosecution would have 20 minutes for their cross and recross. And then at the end, you would have up to 5 minutes for a closing argument. Are redirect and recross required, or can you waive that? You can waive redirect and recross, but I would consider whether or not there's a question that you feel needs to be asked or reiterated, because that's going to go into possibly your score as to whether or not the scoring judges think maybe you left something on the table if you've waived recross or redirect. Can you turn the volume up? Jamie, can you hear me okay?
Yeah, I hear you well. So if the volume is all the way up on the participant's computer, maybe they need to go into the audio settings on their Zoom and turn the audio up there. For some reason, it's 2 different settings.
Okay. Jasmine, I'm not sure if you heard that feedback. I'm gonna type that. It was my device, so it might be that. Jamie, do you mind just typing that in the chat for me as well? Thank you. And then as far as the time limits go, time remaining on one part does not get transferred over. So if you're the prosecution and you're on direct and you only use 20 of your 25 minutes, you don't get a bonus 5 minutes anywhere else. The time is just lost. Okay. You don't have to use your entire 25 minutes, but you can't go over it. And this is just a video of this past year's state competition, the state finals. It is available on YouTube. I recommend watching it if you've never participated in a mock trial before. The sound is not working, so I was gonna play it for you guys, and then I can't figure out how to get the sound to go through Zoom correctly. But you see them setting up, you see them sitting at their tables, you see the judge coming in, you see the introductions, you see the entire trial start to finish. And so I do highly recommend going to YouTube. You can search Texas High School Mock Trial. It'll come up with our page. And then this is the championship round for this past season, 2022. And you may also see Jamie in the video because she was a scoring judge for that final round. And so if you have questions about the format, how it works, anything like that, I really recommend this video. It will walk you through, again, sort of everything. It doesn't walk you through it rather, but you'll get to see in person all the things we've been talking about today and see for yourself what it looks like. And these were the two top teams in the state. And so it is an excellent trial. I will say also they were very tired at this point in the competition. But if you have any questions about what it looks like, where do we sit? How do we set up? What's okay, what's not? I think this video will really help reassure a lot of that anxiety about just some of those basic questions that you might have. Oh, it started automatically. Okay. Independent research relating to the case. Generally speaking, you can do all of the independent research that you want to do it to understand facts, to understand the rules of evidence, anything like that. But that does not come in. So an example would be if you went and did independent research to better understand the rules of evidence and you found like a really great explainer about the rules on hearsay and the exceptions of, that's cool, that's great, but you don't in the middle of your trial get to say objection hearsay. Well, according to the article that I read, this is an exception because blah, blah, blah. The presiding judge will say that's outside the facts, you can't bring that in. But if it helps inform your understanding, it's fine. Should any independent research suggest or prove that any facts in the material are incorrect or inaccurate, the case materials control. So an example would be if the problem says the sky was pink on the particular day in question, but your research indicates it can never be pink, that's never actually pink, a witness can disagree as to the color of the sky if that's within their facts. But nobody can testify that it's scientifically impossible for the sky to be pink. Okay, and that's just a silly example. We're just trying to give you examples of how you can't bring in independent research. The facts of the facts in the materials will control. Trial communication. We do not allow the use of computers during in-person trials. Any devices brought into the courtroom will be confiscated, not into the courtroom. I guess if somebody's behind the bar, it's fine. But if you're in front of the bar and we see that you have a computer, we're going to ask you to close it and put it away. And if you refuse to do that, that's going to start turning into a problem. And the main reason for that rule is because we don't allow communication between the team members actively participating in a trial and those who would be just viewing the trial at that time. And so that's just a way to enforce that particular rule. Coaches, teachers, observers may not talk to, communicate with, signal, or any way coach teams during a trial. And I want to be very clear, attorneys can talk to each other, witnesses can talk to attorneys, and attorneys can talk to witnesses. But anybody who is, what we call behind the bar, meaning they're in the gallery, they're watching the trial, they cannot communicate. And I will tell you, you're not as sneaky as you think you are if you've tried to do that in the past. I've seen it happening. I know Jamie has seen it happening. We can see what's happening when we're presiding, and it's pretty easy to tell when that kind of thing is happening. And this also includes like any sort of signal to like speed it up, right? Like slow it down, anything of that nature. And also, to be very clear, timekeepers are also not permitted to communicate with their team during the trial. We saw that a little last year where timekeepers were sort of giving hand signals to their, like during closing, like you're going too fast or you're running out of time. The only communication timekeepers can have is through their timekeeping cards, or if somebody asks for a time check, and then the presiding judge will ask the timekeepers to say how much time is remaining. Other than that, the timekeepers are not permitted to communicate with anybody on who's participating in the trial, except through the use of their time cards. Can the defendant sit at the counsel table for consultation? I'm going to say yes. However, most courtrooms are not necessarily going to have room for 4 people. Some courtrooms, it's a struggle to get 3 people at your table, is how I would say that. And so that is totally left to the discretion of the teams. If you want the defendant sitting there like they would be in a real trial, totally fine. It's just going to be a space logistical issue in some of the courtrooms that you may be participating in. Would you say that that's fair, Jamie?
Yeah, absolutely. I've seen it both ways. I don't think any judges are going to draw any inference if the defendant is not at the table versus there. Like Jessica said, it's really just a space issue. And if for whatever reason the presiding judge asks the defendant to go sit with the rest of the witnesses, then just have them do that. But yeah, that's fair.
Yeah, and it won't affect the score one way or the other. It's not a rules violation one way or the other. I know in Dallas County, some of the courtrooms we use are very snug. People are sort of sitting on top of each other, and you may not want to have that extra person sitting at the table if you can give yourself just a little bit more room having them sit behind you. But that's a great question. Rule 4.19 gives a list of objections. It is not an exhaustive list, and so the only reason I bring this up is because I don't want you to look at this rule and go, oh, well, I thought this other thing was an objection. There is a rules of evidence packet that should be available in addition to the case materials. It should be posted separately. So it's the competition rules of evidence. That has all of the rules of evidence, including all the various objections that can be made. And so that's the only reason I highlight 4.19 is because I don't want you to read that and go like, oh, well, there's only like 4 objections listed here. You can make any objection within the rules of evidence for the competition. Okay. And then in terms of presenting exhibits, I think we're going to go over that a little bit in our breakouts. But 4.20.1 and 0.2 have really a breakdown on what you should do to introduce exhibits. So if you really have no idea, feel free to like read those rules. That might give you a really good basics on like what to do and say. Are we allowed to have a list of objections with us during the competition? Yes. If you have a list of like your most common objections, I will say that I have done that as myself as a trial attorney. I will have, when I started out, especially, I had like my top 5 objections, just because sometimes you make the objection and then your brain is like, what is the word I'm trying to find? And so it can help to have that. That's totally fine. Especially if you're, having, I guess, especially if you want to make sure you have some of the specific language of some of the objections, that's totally fine as well. I mean, obviously we can see if you're reading stuff versus if you know it. But it's totally fine if you just need that for a little bit of a reassurance. I honestly don't remember why I included disputes regarding conduct during trial. I think it's because a lot of times, I guess what I would say is most of those disputes need to be taken up at the end when the judge is asking for any rules violations allegations. This is about conduct, not about, you know, the format of the trial or anything like that. If you think a witness is maybe not testifying correctly, I would say more often than not, what needs to be happening is that the witness needs to be questioned more specifically. It's not necessarily a rules violation, but this would be if you see someone passing notes, right? If you think someone just flagrantly did their job incorrectly, if it's affecting the trial flow, yes, stand up and alert the presiding judge, but most of that can really be taken up at the end of the trial. But most importantly, the presiding judge's decision is really going to control on most of these issues. If it's a rules violation allegation, the way that typically works is the judges take it under advisement and then they'll come back to like the scoring room for the judges. They each individually can determine whether or not they think a rule was violated, and then they can also consult with committee staff or whoever's running the competition to make a decision as to whether or not points should be deducted, whether or not anything should be affected by the alleged rule violation. How do objections affect our score and points? Jamie, would you like to answer that question?
Yeah, so the answer to this is a very lawyerly answer, which is depends. It depends very much on who's scoring your round and their thoughts about, did this team object too much? Did they not object enough? Did they make the correct objections? Did they support the objections correctly? So if we're talking about those types of objections that are coming during testimony, then yeah, it really just depends. I think we're going to actually have a presiding judge panel next week that's going to be videotaped and available to everyone. And this is definitely one of the questions that's going to be addressed by that panel, so you can get a range of answers about judge preferences. But what I'll say for that, because I know that's an extremely useless answer for teams that are preparing, is it should be whatever your team is most comfortable with. For some teams, the strategy is to object more because it throws the other team off their game. As long as you have supportable objections, there's nothing wrong with that strategy. For other teams, you object only when it's absolutely necessary to the case itself, and that's a good strategy too. So it's just something to discuss with your team and figure out which strategy you prefer to use, because in terms of scoring, it really differs depending on the judge.
Yeah, and I will also add that, you know, at the beginning of each witness, you're generally asking some like what we call foundational questions, where you're just having them introduce themselves and you went to college or you did this thing and you work in whatever field. And sometimes those foundation questions are very leading. You can object to leading. You're not going to get any points for objecting to leading during really basic introducing questions for a witness. Now, once you get outside those first like 5 or 6 questions when there's leading and you object to leading, yeah, like I like to see that you know that that's a leading question. I like to know that you identify that, oh, they're getting into hearsay, or that they're bringing in details that are not relevant to the case, and you know, because we always try to include facts that are not really relevant. So if you start getting into those things and you know the other side objects to relevance, I might be like, oh yeah, they know their facts really well, they know that that's actually not relevant. So they can absolutely get you. For me, I would say great objections is where I see the difference between like 8s and 10s, right? If everybody's asking really great questions and doing a great examination, you may all get 8s. But if you're doing really effective objections and really effective crosses, that's when you're going to get some extra points. And on the flip side, if there's a lot of objections being made while you're like, for instance, if you're doing the direct and the other side's objecting a lot and you handle that really well, and you do a great job sort of withstanding all these objections, and you do a great job arguing against them, and you do a great job continuing with your line of questioning and not getting thrown off, that is something that we see that sets apart the good attorneys from the great attorneys.
And one other thing I'll add to this discussion is, if you're a team who has decided one of our strategies is going to be to make a lot of objections, obviously supportable, but we just want to object more rather than less, watch your presiding judge during the trial. And if you see your presiding judge start to roll their eyes or put their head in their hands or give you some body language that starts to indicate that they've had it with the objections, take that into account and maybe decrease the number of objections you're making. Every presiding judge is going to be a little bit different on this, but some have pretty strong feelings about that. So just watch them during the course of the trial, and they're going to, through their body language, give away how they feel about what you're doing.
Right. And I think another signal for when that's happening, I think I fall into this, is when I stop asking for arguments for an objection, it means you've made the objection enough times that I know you both know the arguments to make. And so that's my sign of like, we can just move on. I'm just going to rule. So when that happens, that's also a sign that the presiding judge is like, you've made this objection plenty of times, we're good. So the question in the chat, are you referring to attorneys disputing an issue or the team advisor raising a concern? Well, the team advisor should never be standing up in the middle of a trial raising a concern and interrupting anything. If the team advisor or coach has an issue, those can be taken up directly with the committee after a round. Generally, I will say the one exception to not being able to talk to the team is at the very, very end, when the presiding judge asks for any allegations of rules violations, we will typically allow you to consult with the rest of your team. That is the one exception. And so that can be when you can discuss those and bring those up to the judge. Are witnesses allowed to have papers with them? When you say papers, are you referring to the witness statement or are you referring to something else? Notes. No.
Yeah, the witness, in terms of my understanding, the witness can't bring anything up to the stand with them. If the crossing attorney wants to impeach them with their statement, they will definitely put their statement in front of them and they can use it for that purpose. But and this is something we can check on, but I'm not even sure if the witness is allowed to bring their own statement up with them. I think
I don't believe they are. You should know your statements as if you were in fact that person. Because outside of like experts who would be referring to notes necessarily, and we don't really even allow that in our competition, but even in real life, someone wouldn't take notes up with them. Witnesses cannot have any form of notes. Thank you for, I just don't have the rule right in front of me, so I didn't want to cite to it, but that was my understanding too, is like, you can't take anything up there with you. And again, like Jamie said, if a witness needs to be impeached, that's when the attorney on the other side would put the witness statement in front of them. So I hope that answers the question. Were there any other questions about the rules, the basic format? If you're starting a new team, can students come and watch competition rounds to learn? We do allow, historically have allowed observers in person. That has been limited. Well, obviously that got very limited on Zoom competitions just because Zoom had an upper limit of how many people could actually be in the Zoom. And then this last year in person, we had limits because of COVID. I'm not really, it's going to depend on what region you're in. It's going to depend on the rules in your particular, like the county that the competition is taking part in, things of that nature. But generally, yes, you can have observers. And then again, I would point you to the YouTube page where we have this past year's, which took place in person. And then we have the year before that, which took place on Zoom. So it's not quite the same, but you can still get an idea of questioning and the basic format of the trial through that. And you can order DVDs of past finals from Melissa Garcia. Yeah, but I will tell you this past year is like what I linked to is on YouTube. So it's there free for all. Just search Texas High School Mock Trial and it should come up. To clarify, we can observe regional competitions. So generally speaking, the rules for observers, you'll want to ask, you'd probably want to get permission either from Melissa or from whoever's running that regional competition to be able to observe some other team, because usually observers are limited to the school that they're from. So if you go to Smith High School, you can be an observer for the Smith High School team, but you generally can't be an observer for another team without permission either from that team or from the competition runners. And then, yeah, there is a specific rule about viewing trials. But usually we're talking about having extra observers for the team is what we're contemplating. So if you're wanting to observe a competition that you're not in, you'd need to really get specific permission from the competition runners and Melissa to do that. And so those are great questions to ask Melissa about how you could go about doing that, especially if you're one of the schools that doesn't have a regional competition. That can be really beneficial, I think, to be able to watch.
Yeah, and I'll add to, for state competition, if your team has already been knocked out, but you happen to still be in the courthouse, then if there's room in the courtroom to come in and watch state, there's no rule against that.
Yeah, exactly.
You're not one of the schools competing at that point.
I got a question. Can attorney team members in their own communicate and help one another know when to make an objection? Yes, again, that's where it could be helpful to have a list of objections. You can point at them for your team member. Again, as presiding judges, we can tell when that's happening, and even scoring judges can usually see that it's happening. It's totally allowed and totally permissible, but we may not give attorney A all the points for the objections if it's very clear that attorney B is the one telling them what objections to make, if that makes sense. Were there any other questions? Okay. The next thing I wanted to talk about is the dress code. Specifically, the rules about the dress code is that there are no rules about the dress code. We do not have a specific dress code for the competitions. That said, we do expect all participants to be nicely dressed. Absolutely nothing that can identify your school at any point. So if you have a leather jacket or anything like, a school jacket, school sweatshirt, please do not bring those into the courtroom. Every competition really thrives on the judges not knowing who the teams are and not being able to have any sort of bias or anything like that against teams or for teams. When we say nicely dressed, however, that does not mean everybody has to be wearing a suit. Okay. We see a lot of anxiety about this each year. If you can't afford a suit, you can wear like a very nice pair of pants and a jacket is totally acceptable. It's totally fine. I have some pictures, but there's lots and lots of pictures on the Facebook page of past competitions. Feel free to scroll through there. You will see examples of all sorts of dress and what students have worn in the past.
And one thing I'll add to that is wear comfortable shoes that you can walk in. Whether you're an attorney or a witness, you're going to be walking around through the well, back and forth to the stand or just around the tables. And I have seen some heels that are so high that I am actually worried that the participant might fall over, because they're very cute heels, but they're not necessarily useful for this purpose. So I would just make sure your footwear is comfortable and useful, as opposed to being the perfect shoes for your outfit or something like that.
Yes. And then one last note is for any female identifying or female presenting students, you are absolutely welcome to wear pants. There is no requirement that you wear a skirt or dress. There is no expectation at all that you wear pantyhose. If somebody in your life is telling you you need to wear pantyhose, you can point them back to this presentation where I said you don't have to. If you like pantyhose, by all means. If you have a really cute pair of leggings or something that you want to wear under, go for it. But there is no requirement No expectation that you wear a skirt dress or wear pantyhose with a skirt and dress. Okay. So we're running a little behind, so I'm just gonna click through the pictures, but again, those are all on Facebook. I pulled all those pictures from Facebook. You're welcome to go look and see how students have dressed in the past. The only thing I'll add is remember witnesses are not permitted to wear costumes. Okay. For trial etiquette, generally just be polite, you know, treat the presiding judge as you would a real life judge who can in fact throw you in jail if they don't like your behavior. We don't have the power to throw you in jail, but if we start getting sassed by team members, it's going to start to affect your scores. And then ultimately the presiding judge's rulings on objections and that sort of thing, those control whether you like them or not. So continuing to argue when they've told you to move on is again going to start to affect your score. And then witnesses, remember that when an objection is made, you do not speak until you're either instructed to answer the question or until the judge says, go ahead and ask your next question. I will say as a presiding judge, if I have to admonish a witness to stop talking or arguing during an objection, they're losing points. So those are just some really basic tips that I had. Is there any questions about the rules, the format, dress code? You can drop them in the chat. You can send them to me. You can ask them out loud. Okay. Let's see.
And if anybody has questions that occur to them, certainly in the breakout sessions, Jessica and I can address those in the 2 different breakout sessions. So your questions can be, even if they're directed to this portion, you can save them for those as well.
Yes, absolutely. So at this time, we're going to transition to the next part of the clinic, which is there's sort of 2 parts to this. If you are an advanced student and you feel comfortable answering questions, you're absolutely allowed to speak up and do that. But this is a chance for the students to ask each other questions. So if you are a beginner student and you have questions for your advanced students, this is the time to do it. And we also have with us Colleen Collins, who is a mock trial. What am I trying to say here? You are on the SMU mock trial team. And so she's competing at a law school mock trial level. And so she is also here to answer any questions you guys might have. And so if you, again, don't feel comfortable saying them out loud, you can put them in the chat or you can send them to me and I can ask the question for you. I did get a question about in cross-examination, can you quote, refer to the written testimony when questioning a witness? Colleen, do you want to answer that question for us?
Sure. I'm not sure if it's different in high school, but likely not. Pretty much only if you're impeaching or if it's been admitted already.
Yeah, and so when she means impeaching, that would be when you start to question the witness about what they said and how is it different from their written statement. And there's no like magical way to do that, but there's a general format that you can follow. And I don't know, Jamie, are you planning to go through that with your advanced students?
Not specifically.
Okay.
We'll see some examples.
I will say that's more of an intermediate advanced skill than a beginner skill. Can attorney and witness pairs communicate during the trial? If you mean the witness is on the stand, the answer is no. Once the witness is on the stand, all communication occurs through questioning. But if you mean if a witness is sitting right behind you, can they talk to the attorneys? The answer is yes. As long as they're one of the 6 people participating, they're absolutely allowed to communicate and pass notes.
If we're waiting for other questions, I'll ask Colleen a question. So it's nice to meet you, Colleen. Did you do mock trial in the high school or college level?
I did not. So my high school experience, I was virtual for 3 years. So didn't have the opportunity to do it. And in college, we didn't have a team. But I did do forensic and debate my last year of college. And it was the first year that our school had a team, and we won it, at least one award at every competition we went to. So great experience to transition me into mock trial.
Definitely, that's great. Did you find that your participation with debate, how was that different from your participation in mock trial on the law school level? Did it prepare you for it, or was it something that was such a different thing that you just had to start over?
Yeah, so I actually did the forensic side of forensics and debate. I didn't actually do the debate side, but I judged a high school debate in college, so I kind of saw both sides. But I think it absolutely prepared me. Being able to give a 10-minute speech at the end of college and not learning to not have filler words, learning to not try and stutter over my word, like stumble over my words, learning to be confident in what I was saying, absolutely translated to mock trial in law school. So it definitely helped prepare me.
Other questions for Colleen or for the advanced students? This is a really great opportunity to ask those questions. I assume a lot of you are thinking about law school, thinking about becoming lawyers, and Colleen's a few steps ahead of you on that path. So yeah, if you have any questions for her, because I know I have a bunch and I can keep asking, but I want to make sure that the rest of you get a chance.
Yeah, the questions that I've gotten are really about the previous portion that are like rules related. So I'm holding on to them. I'm not ignoring them. We'll come back to them in a minute. I will say for the advanced students here, one of the questions that was asked a couple of times last year was, I think some people in the chat have already indicated that they're starting new teams. There was a lot of advice like, how do you recruit members? What arguments did you find persuasive to get people to join your team? So if you're an advanced student and you have any feedback about that, I think some of our newer teams might appreciate some of that. And again, you can just turn your mic on and start talking.
So we have one question in the chat. What is your advice for starting a case from scratch? Meaning at the beginning of the season, you were handed an elephant to digest. Suggestions on order of operations. So Colleen, I'm actually going to throw this one to you. What is the strategy that your team at SMU uses?
Yeah, so we have a few different teams. I'm on a team that has 4 different coaches. So that's really helpful. And we start by the first week, we just read the problem, we go through it. Everybody has their own strategy if they highlight or they put notes or whatever they do. And that practice that we meet at that end of that week is separating the good facts and the bad facts for each side. So we have eyes on them. So we start by doing that. Then we will start by openings and closings is always how we start as far as building our arguments. And then every week thereon will be some sort of an element of the case. So we'll start with, after openings and closings, we'll do directs, then we'll do crosses, and then we start piecing it together in actually building that full case. We also have a session on objections. We have a session on foundations. We have a session on just different things we might encounter. We have a session on pre-trial matters. So we make sure to cover every base and fully digest that problem. And if we get to a point in the semester and we realize, wow, okay, we missed this really important fact that needs to be on, we change it. Or if clarifications come in from a competition packet from the people that wrote it, and it changes our argument, and this just happened this last semester. We had a argument and the leads of the competition were like, so you can't make this argument in a clarification, and we were like, cool. So we had to go back and completely take that argument out and rebuild our case just a few weeks before competition. So we lean on each other at that point, but it's literally starting straight from just reading the packet to then building a case.
And does it make a difference if you, I guess that wouldn't necessarily apply on the high school level, but I think what you said about changing things up as you need to throughout the course of the competition is really important. And does that have to do also with if you're an attorney and you're asking certain questions and you're realizing that that witness is just never giving you the answers that you think they should, then you go back and you rethink the types of questions that you're asking there?
Yeah, so that's more on the spot during competition, but we always practice like crazy with our witnesses, because we'll play each other's witnesses even if we're not playing each other's witnesses in the competition. So this past competition, we did play each other's witnesses. So we typically start where our coaches are actually playing the witnesses so that we can see different strategies and see how people might answer, and see how other people might, try and throw you off, or some people are just really cooperative. So we try a ton of different strategies so that we have practice with that. And then we'll move on to actually playing our own witnesses closer to competition, and preparing them how to effectively do a cross without like being rude to the other team, but also getting our point across and not just giving them every answer they want, but also being respectful, but bending the answers to get a little more favorable for us. So we do a lot of practice with witnessing. We don't really ever do a direct or a cross where we'll not have a witness. Like, we're not just going to go through questions. We're going to have a witness, somebody playing a witness, so that we have that experience going into the competition.
And Colleen, let me ask you a question about witnesses. How often, how do you think witnesses should prepare?
So I think starting by reading the case packet, and especially their section, is really important. Because if you don't know that section, you're not going to know how to answer those cross questions. You might have questions written out for a direct, and know that because you've worked with your partners so much. But if you don't know what is in the packet about you, you can't effectively answer cross. And so I think reading everything and knowing your information is super important, and then practicing with your counsel so that you are able to effectively do a direct, and then practice crosses whenever you can, so it's not so intimidating going in and having somebody ask you questions you don't want to answer, and that you're used to that, so that you get your bad facts out on a direct. You get them out early, as much as possible. Of course, it depends on the fact pattern, but if possible, getting them out early so it's not as harsh on cross. So reading it, knowing what you're talking about, and then actually practicing and going into the competition confident in what you're going to say, because confidence is so key, and doing your best to be absolutely factually accurate while also bending it a little so that you can answer a cross question and still kind of make it in your favor.
Yeah, and I would also add to that, I think that's a great answer, Colleen, but also being more specific is knowing every single detail of the fact pattern of the witness that you're portraying. And so finding a friend to help you just say like, well, on October 7th, what happened? And you being able to recite that almost like you're doing, a test with flashcards or something. That can be really helpful because, again, like Colleen said, when you get on cross, you know all the answers. There's nothing that they can ask you that'll surprise you. That was a great answer. Colleen, I'm going to ask you one of the questions that I got directly. What are some of the best ways to practice speaking confidently and eloquently for trial?
Yeah, so practice. As far as, I'm someone that writes out like word for word a open or close. And then I know that by the time I get to competition, it's not going to sound like that. I know that it is not going to sound exactly like is what on that sheet, but that is okay. And so I practice it, I read it a bunch of times out loud, I read it to myself, I practice it in front of other people. So I get used to, moving around the courtroom. I get used to being confident in what I'm saying. And then I also gradually start to get to that memorized point. I'm someone that likes to start a little early with memorization, but not too early because I know things can change in my open or my close. And so taking the sheet away and seeing what you can do, and then starting to memorize it, paragraph by paragraph, sentence by sentence, or however you prefer to memorize. Speak it in the mirror to yourself. It's gonna feel silly the first time you do it. It's gonna feel like, what am I doing? But it's gonna build your confidence to, look in the mirror and be able to confidently say your argument and confidently and eloquently. Also, like, don't be afraid to change your words. If you say something and you're like, that didn't make sense, well, you'd want to change that before you get to competition so that you're not tripping over it, or you're not, like pausing after because you didn't think it sounded right. And also, don't ever apologize for, misspeaking. If you misspoke, just fix it and move on. Do not ever apologize. Don't be like, so-and-so did this, this, and this. Oh, I'm sorry. No, so-and-so did that, that, and that. So-and-so did this, this, and this. So-and-so did that, that, and that, so that you fixed it, but you don't need to apologize for that, especially not in the middle of an opening or a closing. So I think just the practice is really important, but doing it in front of other people and getting critiques, that is super important, because that's what's going to happen during a competition. You're going to get critiques after. That's going to help you build up. So getting some experience with that in the beginning is important.
Yeah, and I will say, your tip of writing it out word for word at the beginning, I'm one of those people who writes differently than I speak. So I can write it out, but then when I start saying it out loud, I have to go back and edit for like what actually works for me and what I feel comfortable saying versus what I feel comfortable writing. And so don't be afraid to do that as well, is to tweak it to language that fits you and that you are comfortable saying and presenting, because it doesn't have to, this is not a one size fits all where everyone has to present exactly the same. We love to see your personality a little bit, so long as you're within the competition rules, you're still presenting correctly, all of those things. But if you have a different way of speaking and a different way of sort of orally presenting arguments, go for it. Like, we love to see that. I saw a question in the chat about how often do you record yourself? I will say I never record myself.
Yeah.
I get recorded like this. I will not watch it back, because it's that thing where like how Jamie hears me is not the same as how I hear me. So when I hear the recording back, I'm like, oh, is that really how I sound? I'm very fixated on that and not fixated on what I'm doing or saying, but it's different for everybody, right? You see that with actors in Hollywood. There are some who can absolutely watch everything that they do, and some who are like, please don't ever show me like a single clip. I can't watch it. So do what works for you. If you find recording and watching it back works for you, go for it. For me, it would be standing in front of my mom making arguments that she has no idea what I'm talking about, and I'm just like, which part didn't make sense?
Yeah, and I think either strategy is really helpful to find out if you have any kind of speaking tics that you don't know about. So if you say the word a lot, if you use the word like a lot, and I of course just said but when, as litigators, when we take depositions or we question witnesses at trial, you get to see your transcripts afterwards. And so you're not necessarily watching yourself on a recording, but you are reading what you said. And it's amazing how many times I've read those and thought to myself, oh, I really need to fix this. I'm starting every sentence with the word so. I'm starting every sentence with the word and. I'm just doing weird stuff that I have no idea that I was actually doing. And any of those strategies is going to help you figure that out. And it's something you can be conscious of as you're continuing to practice.
Yeah,
I
and
will
there's,
say-
oh, sorry, Colleen, go ahead.
No, you're fine. I'll say that my first year of mock trial, I was really, of course, there I am with the tic, but I was really bad about starting every question with and, especially on cross. And then my hands, I would move my hands in really weird ways. Like, my team used to they still do, make fun of me because during competition last year, I had like an ice cream scoop when I was like trying to say something. So now I very eloquently do this instead of that. So it's also important for your hand motions to practice, because naturally, however you speak is however you're going to use your hands. If you're normally using your hands while you speak, you're going to do that during trial. If you don't, you're not going to. And finding that balance is super important. If you want to make a point with your hands, if you want to, 1, 2, 3, if you want to point out something here and then there, whatever you want to do. Practicing that is super important, because then you'll not get to competition and do something like an ice cream scoop as you're speaking. So.
Yeah, and what I was going to say is, we don't have court reporters keeping transcripts during competitions, but the speech to text technology has really improved. You can just do that on your phone anymore. So I do recommend doing that so that you can go back and read how you're asking questions, because that can be an eye opener. For me, I think I just said like a couple of times, and I did it again. When I read back transcripts, I say the word like a lot, and I don't realize that I'm doing it in the moment. And so that can be really helpful as well. It can also just be really helpful to have like your best friend who you trust more than anybody in the world to sit there listening very critically, who you're like, I know you still love me, even if you're telling me I said like 17 times.
That's also really good for direct and cross. I had a friend this past semester, I was like, you need to play the character like somebody would play a character, and you're not on my team, so I can see how I might differ, and help me memorize it, but it also helped me see a different perspective that a team might take, and I was able to like be able to more effectively do that director cross, and also learn the character even more myself because somebody else was playing it.
Yeah, and so I just want to run through a couple of the questions I got, because we are sort of at the limit of our time for this particular segment. Thank you so much, Colleen, for coming and sharing your wisdom. We appreciate you so much. And if you wanted to hang out in either breakout session, you're totally welcome to do so, but I know you have a busy day. One of the questions I got was, if you're a witness, can you dress less formally like you're a civilian? Absolutely. You don't have to wear a suit and tie unless you're of a profession that would normally wear a suit and tie to court. But generally speaking, still like raggedy jeans with holes in a t-shirt, still not a great idea, even if that's totally in character. As a litigator, I very rarely see people come in dressed that way. I did have a client come dressed that way one time, and it was a shock. I didn't think I had to have that conversation. Generally speaking, how you're dressed is not going to affect your score unless it's just very clearly inappropriate, and then it can affect your score. So I would always run your outfits by your teammates, by your coach advisor. You can always send a picture to Melissa, and Melissa will tell you if she thinks it's appropriate or not. And if she's not sure, she'll send it over to the committee and we can get an opinion for you. There are some questions really that have to do with impeaching a witness. I would encourage you to go learn how to impeach a witness. I can't really go through all the particularities of that in like 20 seconds. When opposing attorney, this was a question I thought I addressed. When the opposing attorney objects to leading the witness, can the witness defend or just the attorney? Absolutely just the attorney. As I said, if an objection is made, the witness needs to stop talking. It's not the witness's turn to make arguments or anything of that nature. And to what degree does the attorney speak about each witness during opening statements? And again, that depends. That's going to be part of your trial strategy. That's going to be part of your strategy and how you do your opening, what your theme is. You may speak about one witness and talk about one witness maybe a lot more important than the other ones, right? So you may spend a lot more time highlighting their testimony versus another. It really differs from trial to trial and depending on your theme and your strategy and what you're doing. Colleen, would you agree with that?
Yeah, I would agree with that. And I'm not sure how it works in high school, but I know that in at law school level, we do motion eliminate as well in pretrial matters. And if a judge says not to talk about something in your opening, well, you better take it out, even if you were planning on it. So that's also good to, be able to work on the fly in that way too.
Okay. Colleen, thank you so much for coming. We really appreciate you. At this time, we're going to take a 5-minute break. And then when we come back, we're going to go into our breakout levels for beginners in one room and then intermediate advanced in another room. I'm not sure if those are set up already. Let's see.
I'll set them up right now.
Okay, perfect. Thank you, Yadenia. So we're gonna go ahead and take a break and then we'll be back in about 5 minutes and you can go ahead and join the breakout rooms once they're open. And then we'll remind people to join. And then once everyone's sort of joined the breakout rooms, then we'll go on to the next step. Thank you. Okay, the breakout rooms are open. If you can go ahead and self-select which breakout room you want to join. It's totally up to you if you feel beginner, if you feel advanced or intermediate. You get to decide. If you're having trouble finding the breakout rooms or you need to be assigned, you can just put it in the chat and I can help you out. So there should be at the bottom of your screen a breakout room option where you can click it and select which breakout room you want to be in. Again, if you can't find it or can't figure it out, I am assigning some people. If there is not, Alyssa, just let me know what breakout room you want to join and I can assign you. Okay, so there's just a couple more people. If you can hear me and you're able to select your own breakout room, go ahead and do that. If you don't know how, you can't figure it out, you can just drop in chat which breakout room you want to be in. And I'm going to go ahead, Yadenia, and join the beginner room. And if anybody needs help, I guess you'll still be here to help out.
I sure will.
Thank you so much.
Bailey and Philip, you can select your breakout room. We're breaking down to breakout rooms, so you can select one is for beginner, two is for intermediate and advanced. Philip and Bailey, if you want to participate in the breakout rooms, go ahead and select it. One
Ma'am,
is for beginner, two.
Yes, hi ma'am,
Oh.
I'm trying to, I don't see the link for the intermediate level.
Let me transfer. Let me try to help you there. Do you see it?
Now I do. All right. Thank you. Oh, wait.
Okay, there you go.
Intermediate and advanced, huh? Oh, boy.
Intermediate and yeah, beginners. Do you need beginners?
Well, I've done it for a few years, but I'm certainly not advanced. But
I think
I'll,
that's a good one for you, intermediate and advanced.
okay, ma'am. All right. Thank you.
But if you want to switch it, you can.
Okay. Thanks, ma'am.
Oh, you're welcome. Katie, do you need to be assigned to a room?
I think so.
Which one do you feel comfortable in, beginners or intermediate and advanced? There's two, so beginners is one, intermediate and advanced is another.
Maybe, hold on, give me 1 second. Maybe intermediate?
Okay, let me go ahead and move you
Yeah,
over.
the second one. Thank you.
You're welcome.